Today's video is brought to us by Firearms Legal Protection. Firearms Legal Protection is a legal defense program for lawful gun owners with a 24/7 emergency hotline and plans designed specifically for self-defenders. They are offering a discount on their plan to Ask fans, so hit the link in the description for that.
And also keep in mind, let's not overweigh the importance of making a good impression on the police officer. I think it's important.
Okay.
But at the end of the day, that's not the person making the decision. That's not the person with the law degree. It's going to be a prosecutor. It may very well be a group of prosecutors. If it's a serious case, there could be a review board or something like that.
A grand jury?
Yeah, a grand jury. So that's the decision-making entity in the case. And so I'd be less concerned, not unconcerned, but less concerned about making a good impression on the police officer than I am about trying to convince the prosecutor not to charge the case. So what's so hard? You get usually plenty of time between the shooting and that decision.
Yeah.
It's very easy for a person to come into my office, tell me the story, and let me call that prosecutor. And I've even called the police officers in the past. Say, hey, I know my guy didn't make a statement. Let me tell you some things. He's authorized me to tell you this, and this. I can even do that at the scene. I've done that at the scene, not personally at the scene, but people sometimes will say, look, right after a shooting, I want to speak to my lawyer. Very smart thing to say. The lawyer's going to say, shut up. But then the lawyer's going to say, at least Marc Victor is going to say, hey, are you in a place that you can talk privately? Because if you're not, tell the officer I'd like to speak with you privately. If you are, what the hell happened?
Right.
Hey, by the way, this happened, that happened, this happened. This is probably a good shoot. Maybe we want to preserve the... Hold on. Put the officer on the phone. Hello, Officer Friendly. I'd like you to preserve some evidence. There may be some witnesses there. What have you lost? 10, 15 minutes? Not much time at all. Not to mention that most officers are going to show up, put yellow tape around the scene, and you're not going to have an unsecured scene. As soon as they show up and they secure the scene, they
right.
make sure they're going to make sure that the evidence is not being tampered with.
You know, I have heard from most cops, Mark, that they won't let somebody get on their cell phone when they're in the middle of an investigation because they worry about them bringing buddies who are bad dudes because they're dealing with bad people for the most part too. Some
states vary here. In Arizona, for example, the rule is that the police have to let you talk to your lawyer as soon as is reasonably practicable, which basically means when you're no longer interfering with the investigation. But you know, this provides a great argument for the defense attorney. Hey, I asked to speak with my defense attorney and I was told I couldn't.
Right.
So later on, if there are statements or if things are done or whatever, the defense attorney has an argument to say, hey, wait a second, he was deprived of his right to counsel.
And therefore that's not admissible or whatever.
Yeah, there's an argument there. Right now, some states have different rules on this. Officially, so you know, the right to counsel doesn't attach until you're formally charged. But state constitutions and state statutes provide other rules. There's also Miranda and other things like that. So it's always a good idea to say, I want to talk to my lawyer. And any officer who would consider that making a bad impression upon him isn't a very good officer in the first place. I think, and I would say the vast majority of officers understand that. I have had, on many occasions, shootings occur. People didn't make a statement. They called me. I talked to the officer, and we have successfully avoided charges. I had two, probably in the last year, that were looked at for first-degree murder cases where the person died, no charges as to both. And so it happens. I mean, for the most part, prosecutors do a decent job at deciding whether to charge or not. Grand juries is a slightly different question. So I've already mentioned the fact that it's not your burden to prove anything. I mean, Mass presents it a little bit like, you know, you've got to do this and you've got to do that so you can sort of prove your case that you're the good guy. This reverses the burden of proof. You don't have to prove a thing. The question in a criminal case is not whether the defendant proved anything. Admittedly, we defense attorneys want the jury to believe that our guys are good guys,
right,
or good gals, as the case may be. But I can stand up in front of the jury and say, ladies and gentlemen, I don't have to prove a thing here. The question isn't that. The question is, did that prosecutor prove beyond a reasonable doubt every element of this offense? And if the evidence is missing, they have trouble proving the case. If the evidence is tampered with, if somebody walked off with the shells, it creates doubt. And for us defense attorneys, we like doubt. We love doubt, in fact.
Yep.
We survive.
Plausible alternative theories help.
We live in the area of reasonable doubt. So, let's see. I wrote here, comment on failure to talk to the police, the two predators. I think we covered that. The other thing is, you know, when Moss mentions that he sort of assumes that, well, they already know you're the shooter. Maybe, but maybe not, right? I mean, you don't know. Sometimes it's not so clear. The police may show up and there's a dead body on the ground and you might be there. There may be other people there. Maybe there's not other people there. There can be questions about whether you were the shooter or not. I could easily see an argument, ladies and gentlemen, so-and-so was certainly shot and dead. Maybe the gun was found at the scene. Where's the evidence my guy is the guy who shot him? Why would you give that up?
I'm having a hard time arguing with that, but it feels wrong to me, Mark.
Let me tell you, well, I can tell you why it feels wrong to you, because I think you are starting from a different spot than I'm starting from.
Yeah, I mean, you're looking at a lot of gray areas.
You're starting from the good guy with the good shoot perspective.
Yeah.
I'm starting from the maybe good guy, maybe bad guy, maybe good shoot, maybe bad shoot, maybe gray area shoot. People hire me to get them out of a situation, okay? As an advocate. They don't hire me to sort of get justice done. My job is to be an advocate for my client and make the government dot the I's and cross the T's and prove every element.
Yeah, and you know, my job as a defensive trainer is to get people to not do the gray area and the bad guy stuff, but only do the very righteous stuff.
Right. So we have slightly different things we're talking
missions
about here, right? Very important. The thing that probably made my head explode, that Moss said, is this question. Just want to let you know, I can't think of any reason why you might not say, look, I'll testify against the guy, or you're going to get full cooperation from me after I talk to my lawyer. Well, that's great if you are going to get full cooperation, but what happens if the guy says that, especially in front of the body cam? Hey, look, man, I want to talk to my lawyer. I'm going to testify. You'll get full cooperation. Then he comes in and talks to the lawyer, and the lawyer says, you know, there's an argument here that maybe this was a bad shoot. Maybe you thought it was a good shoot. You're shooting because somebody is stealing your TV, and I point out deadly force to protect property, generally a bad idea. Maybe it was to protect property. Well, it wasn't. We got a few issues. Maybe we'll do this case differently, and we won't have you testify because they can't prove the case. Wasn't that going to be interesting when the prosecutor pulls out the videotape of you saying, I basically agree to testify against this guy, or I basically are telling you right now, give you full cooperation. Well, we wanted you to come in and give a full statement, and he said no. Now, there's arguments that this may still not be admissible, but there's also very good arguments that this may be admissible because you have sort of opened the door to this by saying to Officer Friendly, who may turn out to be Officer Unfriendly for all you know, right? Because cops sometimes, look, hey man, we know this is a good shoot. We're on your side. We just want to wrap this thing up and we just need to get your statement, right? Police officers can lie to you. They may be thinking, hey, we think he's a bad guy. For whatever reason. So when you make that statement, you basically have predetermined the lawyer's decision with the client to testify or not at the trial, or to give a full statement or not at the station later on, or to go down and do something else, you know, that you may or may not want to do. Full cooperation means prosecutor calls you up and says, hey man, come on down with your defendant. We got questions to ask and things to this and that. I don't want to be deprived of the ability to say, sorry, we'll pass. You guys prove your case.
So I guess what I'm hearing there is it's wiser, if you're going to go Moss's route, to say before making any statements, I invoke my right to speak to counsel.
Look,
that sounds positive, but it's much more neutral.
Here's what I like. I like just shut up. Just shut up works great.
Okay.
And when I say just shut up, okay, give them your name. They have a right to that information. They're going to print you and find that out. But what happened? Who's the good guy? Who's the bad guy? Sorry. In a very nice, respectful way. I even tell people to say, look, I got a buddy, Marc Victor. He's a buddy of mine. Marc could kill me if he caught me talking to the police without him. If Marc says it's okay, I'm happy to talk to you, but I like to call Marc first. Something like that, right? In a nice way. I'm not going to say anything until I talk to my lawyer. And by the way, it's always important to get the word lawyer or attorney out.
Yeah.
And it's very important to not be equivocal about this. The statement, I think I want to talk to my lawyer, or maybe I should talk to my lawyer, or something like that, is meaningless.
Right.
That gets you nothing. The statement that I want to talk to my lawyer. That's a very clear statement about wanting to talk to the lawyer. And then later on, if they get you to make a statement, there's a very good argument it's coerced, right? Because you said you wanted to talk to the lawyer. There's a good argument to suppress that statement. It's best just to shut your mouth. Let the lawyer speak on your behalf, or, as I have done in some cases, like the Steinmetz case, which had a lot of national publicity. If you remember, and Steinmetz, by the way, I should note, has given me permission to talk about his case publicly. But Steinmetz didn't make any statement at the scene. He kept his big mouth shut. He got charged. Later on, we reviewed everything. We talked about it. I understood what happened. We decided to do a press conference. We called the press. We called people. People came to the law firm. And Mr. Steinmetz made a statement to the entire world. No problem. Because we talked about it. We saw what the evidence was. Ultimately, case dismissed, all charges dismissed, AR-15 returned to Steinmetz, and petition to declare record granted. Everything sealed about the case. Not even in his police report records. Sealed. So we got everything you could possibly get under Arizona law. He kept his mouth shut. It was the right thing to do. He still made a statement. He made his first impression.
Right.
He just made it later.
Made it at a different time.
He made it at a different time. So, and I guess I would just sort of end by saying the other thing that I worry about, just because I've been doing this 26 years and I've represented I don't know how many thousands of people in major cases, and I should note, absolutely, one of the most common things I say to people is, man, if you had just kept your mouth shut, there's a real good chance I could either A, beat your case, or B, get you a much better deal than you're looking at now. But because you opened up your mouth, I can tell you that said a lot. I also get a lot, yes, I did talk to the police, but that's not what I said. I've got many cases, I even had one shooting case where my guy said that. He said, I never said that statement. That was in quotes in the police report. Fortunately for him, it was a recorded statement, and I got the recorded statement, and absolutely true. He never said that. But think about if that statement had not been recorded.
Yeah, if it wasn't on body cam, that was trouble.
It's sometimes keep your mouth shut. And then the point I wanted to make is I think Moss is assuming, maybe in good faith, that you'll follow his advice and only say those 5 things. But as you point out, as we so lovingly refer to it as diarrhea of the mouth, people get talking. And why do they get talking? Because police officers are very good at getting people talking and keeping them talking.
Well, and the cortisol effect after deadly force is used, and you had an adrenaline dump. Adrenaline's not a bad thing, but the cortisol afterwards gives you the shakes and all that stuff, and that affects your brain chemistry, and you will talk to process that epinephrine dump out.
And once the police officers got that Pandora's box, your mouth, opened, they're going to keep it running. They're going to keep asking you question and question and question, and they're going to get you to say things very likely, far beyond what Moss wants you to say. So how do you avoid that? Keep your big mouth shut.
Well, friends, you have heard the thorough rebuttal from the criminal defense attorneys. I put them both out there because these are kind of the 2 paths that we see it diverging on. Man, for me and mine, I mean, I think the higher trained you are, the more verbally agile you are, the better verbal communicator you are, you might be able to get away with it. But boy, err on the side of caution. And just like we tell you to err on the side of caution with force, I'm going to tell you to err on the side of caution with what you say.
Yeah, I think the potential upside of the things that Moss is talking about, making a first impression, these are very limited upsides, right? Because the cop could say, hey, this guy's a great guy. The prosecutor may say, sorry, he broke the law, and I don't care. That's the way I see it. So a limited upside to opening your mouth, although I recognize there could be some upside, huge potential downside.
Yeah.
Right? So as a general piece of information, look, if you want to call me up right after your shoot and say, here's exactly what happened, I could give you more information, but even then, I'm going to want about an hour to go through it with you, right? And how do I know that what you're telling me is accurate facts? You might be mistaken about facts. There could be 5 other witnesses who see things differently. People honestly tell me in good faith what happened, and then they're shocked sometimes when they see the video. They say, wow, I remembered it completely differently than that. I think because of the stress of the thing, they may not have an accurate recall of everything that happened. And you know how the prosecutor is going to present that. You're lying.
So cost benefit analysis here. You said something that I think really maybe shifted my thinking here just now, Mark, that if you say nothing, there is a very limited risk. The risk is very limited. The potential payoff is great. If you say things, the potential risk is great. The potential payoff is limited.
Very limited, very marginal, I would say. Almost frivolous, in my opinion. I mean, it's nice if the officer's on your side. That can definitely be helpful. But this officer's not going to be trying the case. This officer's not going to be making the decision on the charging, especially in a serious shooting case.
And so, if you kind of take a Pascal's wager approach to this, you're probably better off. The risk is too great and the payoff too little to take that risk, and you're better off just, I want to speak to my attorney. And then your attorney can do that stuff. Mark, man, this is great discussion. Thank you, my friend.
Yeah, it's a fun discussion. It would have been great to have it live, and we could have gone back and forth and talked about the things that I'm sure we have many, many more points of agreement than disagreement. But the disagreement points are always the fun things to talk about.
Agreed. Thanks, guys.